did the U.S. Supreme Court rule during this session? Good evening, I'm Edel Howlin. Welcome to Red, White and Blue. The 2015-2016 session for the U.S. Supreme Court has had no shortage of high-profile cases, including issues on abortion, affirmative action and immigration. But with the unexpected death of Justice Antonin Scalia in February and no named successor, the Supreme Court has been closely divided on key cases. In what some say is a crushing blow to the White House, the Supreme Court was unable to resolve a case concerning President Obama's executive actions on immigration. Without a ninth justice to break a tie, the 4-4 ruling resulted in what some say is a major loss for the administration. So, just how did a divided court rule this session? Tonight we'll break down the cases and rulings and ask, what impact will the court's rulings have on both the United States and Texas? And how has the death of Justice Scalia affected the court's decisions this session? To help us navigate this important topic, we are pleased to welcome Professor of Law at Houston College of Law, Charles Rocky Rhodes, and Professor of Law at the University of Houston Law Center, Teddy Rave. And leading our discussion are hosts David Jones and Gary Polland.
And Gary, the only way that I could hope that Rocky could lead us through this discussion of these three Texas cases, these very, very, very famous Texas cases on immigration, affirmative action, and the other 4-4, which was the
abortion.
It's a Rick Perry moment. The headline in the New York Times says this is the most liberal decision making by a Supreme Court since the Warren Court. Another headline said, Wendy Davis, former senator who had the filibuster, may have lost the filibuster battle, but she won the legal war. So how do you size up how Texas stands, especially given that it had such opposition and in some cases lost in these major cases?
Well, there's obviously a conflict between what the political values are here overwhelmingly in Texas versus what the political values are overwhelmingly in the United States as represented by the Supreme Court. I mean, there is some tension there, obviously, between those. And we have a court that is, as these articles said, closely divided between Republican-appointed justices and Democratic-appointed justices. And when you have that situation, and we have one thing that's very unusual right now that we haven't really had in our history before, where we've had Republican appointed justices. Some of those would be more liberal than some of the Democratically appointed justices on the court. And we have a lot more kind of a coalescing around the political parties that are associated with the president who appointed these justices, and they are kind of spilling over these political battles or spilling over to the Supreme Court more than we've oftentimes seen, and then breaking down on just Republican versus Democratic appointed lines.
So the law doesn't matter, it's all about partisanship. Is that a fair statement?
I'm not going to go that far to say that the law doesn't matter, but I am going to say that on these closely divided issues, the types of issues that the Supreme Court could go either way, that it does make a big difference about who is sitting on the court. There's no question that having Justice Alito replace Justice Sandra Day O'Connor, for instance, shifted the court somewhat to the right.
And tied into that, of course, is the death of Judge Scalia.
And of course, when he died, it threw the abortion decisions up for grabs, Rave. Is that?
So I think that's right. Now, you said earlier that this is the most liberal, or
New York Times
the New York Times has said this is the most liberal court since the Warren era. And I think part of that has to do, I don't think that's an accurate characterization. And part of what we're seeing is a reaction to the cases that have been filed. These were cases that were filed with the anticipation that they'd be ruled on by a conservative majority court. And all of a sudden, when Justice Scalia died, that's no longer the case. And so we're seeing results of cases that are probably trying to push the law more in the conservative direction, not being successful, rather than in the Warren Court, where I think
well,
the
what
baseline
is your view on the immigration case, where we have this injunction from a South Texas district judge sustained by the most conservative circuit court in the United States, the Fifth Circuit? Why couldn't the Supreme Court get that fifth vote rather than leaving it at the tie? What happened? I guess my question is, what happened in the immigration case, and why couldn't they get Kennedy to uphold the law of the president being able to exercise his authority in immigration?
I'm going to amend that question. I'm going to amend it to say that why is it that the other liberal justices don't believe in separation of powers and doesn't stop runaway executive power, which is really what this case is about.
So I'm going to answer both of your questions in the same way. We don't know. One of the biggest downsides of having an evenly divided court in a decision like this is they vote 4-4, and then they don't write an opinion to explain. We don't even know who voted which way. It just says that the decision of the lower court is affirmed by an equally divided court, which means that the Fifth Circuit's decision stands, though it won't have any sort of precedential value for the rest of the country.
So this is an example where if Judge Scalia were still alive, it probably would have been a 5-4 decision, or maybe even a bigger majority to saying that the president overreached in his executive power.
So I'm not sure, actually. I think that one of the issues in the case was whether Texas had the power to sue, because in order to bring a case in court, you have to have been injured in some way. And Justice Scalia is one of the justices who has historically been the most skeptical of plaintiffs standing to sue based on minor injuries. So I actually don't know which way he would have gone. But you're right, it would have been 5-4 one way or the other, and then we would have had some information about it.
But we did have the Fisher case, which has been around for 8 years. Miss Fisher has since graduated, gone on to have a family. She's probably a grandma by now. How is it that Justice Kennedy, who wrote the majority opinion in the affirmative action case out of the University of Texas, suddenly becomes, the new John Lewis, new Martin Luther King of affirmative action law?
This is fascinating because Justice Kennedy had always said before that he thought that race-conscious programs were okay in very narrow circumstances, but he had never found a narrow circumstance that he liked ever before. And this was quite surprising to me that he actually upheld this program. I have been on this show predicting the opposite in past occasions.
What is the program that he supported?
Well, the University of Texas, what they did is they used a top 10% admissions program for 75% of their class. And then for the other 25% of the class, the discretionary admits, one aspect of that, one consideration, one factor, the factors of the factors to get in was your race. And the claim was that this was too much use of race because you already had enough racial diversity from the top 10% plan. And that this additional consideration of race on top of that made this not narrowly tailored, not closely enough tailored program to survive scrutiny under the governing standard for race-based programs.
So despite the fact that most of the, school districts in the state of Texas are highly segregated, meaning that the top 10% of many of those people would have gotten in, it still did not guarantee the type of diversity that the University of Texas wanted.
That was the University of Texas's claim. Now, one thing that's interesting about this is that on the top 10% plan, they actually showed some statistics that showed, and it was from Justice Alito's dissent, that the students who were getting in on the top 10% plan were actually performing better than most of the students in that discretionary last 25% admission, because a lot of times it is most important what your grades were rather than what your SAT scores or something like that with respect to future potential performance in college.
By the way, Gary, I was top 10% at El Campo High School.
Yeah,
I chose to go to the University of Houston.
Well, they didn't have that rule back then, so you could have gone anywhere.
Good choice.
But I wanted to ask you, Judge Alito was very upset with this decision. He called it affirmative action gone wild, so he thinks the doors have been reopened and it's out of control because of this decision. Your take?
So I think this was the biggest surprise of the term, aside from Justice Scalia's death, because as Rocky mentioned, Justice Kennedy has never before found an affirmative action program that he thought was closely tailored enough. And I think this, I would have and did predict that this would have gone the other way with a very narrow, decision.
Striking down the UT program. And
Kennedy tried very hard to make this a narrow decision. He said that the UT program is unique. He's not considering affirmative action programs across the board. He's very narrowly considering this combination of a top 10% plan and then a discretionary plan beyond that. And he said that the University of Texas has an ongoing obligation to reevaluate its use of race. So it can't just rest on having cleared the hurdle this time. It has to go back and determine whether race is still necessary going forward.
Yeah,
So
there was building on Teddy's point there, I mean, Kennedy's opinion specifically upholds the program as it existed in 2008 when she applied, not trying to actually say it's still constitutional today necessarily, to try to kind of build on that point on how narrow he was trying to make this ruling.
Left untouched by these liberal wins that we are talking about were waiting periods, forced ultrasound, 20-week gestation bans. Where do you see this ruling taking us insofar as litigation on those issues might go?
Before we get to that, why don't we talk about what the ruling is?
So
Before we move forward, and David's idea that we're going to have unbridled abortion whenever, wherever, for whatever reason. So, what are you talking about?
You can easily describe what the court struck down that Texas provided.
Yeah, well, we had the Texas law, House Bill 2, I believe it was, from a few years ago, which had two major restrictions that were challenged in this case. One is that if you were going to perform abortions, you had to have admitting privileges at a hospital within 30 miles. And the other one was that for facilities that were performing abortions, they had to meet the standards for an ambulatory surgical center. And the law was, both aspects of this law were challenged. It's a pretty complicated procedural history that we probably don't want to get into in here. But both aspects of the law were challenged, and the Supreme Court concluded that these two provisions were an undue burden on the right of a woman to choose to have an abortion. That, in other words, that they placed too much of a burden on that right without any showing of a health benefit. And in fact, at oral argument, the state of Texas was asked, can you show that this has helped the health of any one woman? And the answer was no, we can't show that.
I'm going to
That's a weak oral argument.
I'm going to re-ask my question because you amended mine.
But I had a follow-up.
Well, but you interrupted mine.
Yeah, but I had a follow-up on what he was talking about.
Uh-huh.
So I want to focus on that, okay?
All right.
Okay. If you look at the legislative history of HB 2, and I guess before we even talk about that, the Supreme Court had already stayed the admission at a hospital requirements a couple years ago. So that's already been on the sideline for a while. But the rules about ambulatory surgical center had been in effect. But if you look at the legislative history, Texas went forward with a bill in reaction to Kermit Godsnell and his butcher factory in Pennsylvania, and the concern that women are not safe in situations like that getting abortion. So that was their reaction. There may be an argument that they legislated too far, but I thought, my take was, and I want yours, don't you think that was proper legislation to actually protect women's health?
I think to show that it's proper legislation to protect women's health, the situation that you're talking about in Pennsylvania, the evidence was that they stopped doing any kind of inspections whatsoever, that they hadn't been there for years. And so that was a sui generis, that was just kind of, I mean, it's a terrible tragedy what happened there, but that doesn't mean that we should take away necessarily everybody else's rights because of a terrible tragedy.
Well, and I'm again making rules to make sure that, I mean, you have to agree.
But the rules, the old rules in Texas, as long as they were enforced, were sufficient to make sure that didn't happen.
So your argument is they didn't need these additional rules.
I have seen no evidence that these rules had anything to do with women's health.
Which is what the court said. Now, I'm looking towards the future, and there's this one sentence out of Casey, a prior abortion decision where Kennedy was in the majority, where he says, liberty finds no refuge in a jurisprudence of doubt. So what is the future of some of these other restrictions on abortions? After all, since 2011, 250 restrictions have been invented by various states. Is this going to be such a compelling decision that we can expect a lot of other rulings or other state legislative matters to be falling left and right?
No, I mean, we can expect two more because there were two other cases coming out of other states with very similar laws, which the lower courts had struck down and the Supreme Court dismissed those cases. So those are gone. But this is not an issue that's going to go away.
Well, how about 20-week gestation?
Oh, you mean partial birth abortion?
No, 20-week gestation.
Because there's fundamental disagreement in this country on whether abortion should be legal. And the Supreme Court has declared in Roe and reaffirmed in Casey, and it is the law today that there is a right, that a woman has a right to choose whether to have an abortion. We have the debate. We don't have that debate anymore. We have the debate on these other grounds, on these other, let's find ways to discourage abortion or make abortion more difficult to get. And they're framed in terms of let's protect a woman's health. because that's one of the reasons that the Supreme Court has allowed states to restrict the right to abortion. And so we're going to see that continue to play out. We're going to continue to see fights where state legislatures are regulating abortion. And the question is when it crosses the line. And the court in this case said when you are requiring surgical facilities at an abortion clinic and requiring a physician have admitting privileges, that crosses the line. There's no, the health benefits there are just too small to justify the burdens.
There are no such requirements for men who are going through various procedures,
That's
even more dangerous than abortions, correct?
That's a political question.
Well, no, it's not. It actually isn't a political question. It's actually part of the court's opinion was and not just the men, but they went through all the different procedures that aren't covered, that are much more dangerous than these procedures to individuals' health who are undergoing them that don't have to meet the surgical requirement. And then they also brought up the fact that even of the 455 surgical centers that we have in the state of Texas, 360 of them were grandfathered. In other words, they don't meet current standards. So almost, what is that? That's about 80%, 75%.
We should get rid of that too.
Well, we should get rid of that, but it's funny that they're only not grandfathering the clinics in which you can have an abortion. Every other facility, so if I need a shoulder surgery, I can go to a grandfathered one that doesn't meet standards.
Dangerous.
Shoulder surgery, pretty dangerous. Much more dangerous than going to having an abortion, which this has been relatively
but
safe.
I wanted to talk to you. There are two comments in the opinions that in the opinion and the dissent that I found fascinating. We'll see if there's something that you're not surprised with. Judge Breyer, who wrote the opinion, said, determined wrongdoers already ignoring existing statutes and safety measures are unlikely to be convinced to adopt safe practices by a new overlay of regulations. That was part of his argument of why these regulations are not going to really make any difference. But that's the same argument that the pro-gun people use for more restrictive gun laws. So can we anticipate Judge Breyer is going to shift and now be part of the pro-gun forces on the court? Interesting question. And the second one was the dissent by Judge Thomas, who said the majority is now acting as the country's ex officio medical board with powers to approve and disapprove medical and operative standards and practices in the United States.
Lovely. He found wonderful sentences out of losing opinions.
Any comments?
Well, I'll take Justice Thomas's. Justice Thomas is coming at this from the perspective that abortion should not be a protected right. And so he wants to treat the evaluation of the legislature's homework. So the court is sort of saying, did the legislature check all the boxes? And when we talk about constitutional rights, like the right to free speech or religion or abortion, which the court treats as a fundamentally protected right, the court does a little more checking of the legislature's homework. So I think it's that Thomas is not applying the same standard that the court
Let's
does.
see, Gary and I are both criminal law. Let's see if he approves of the Fourth Amendment decision, which I claim means that it is now dead. The Fourth Amendment protecting unreasonable search and seizures is now gone because the Judge Thomas, I think, actually wrote the opinion that says, well, even if you stop somebody illegally, right, and you later determine that there's a warrant for their arrest because they failed to show up for a traffic ticket, whatever you arrest them for and find in their pockets can be used against them, and the rule that says that should have been discluded because of the illegal stop is gone. So where's the civil liberties in this matter?
So what is, I think, the most surprising about this decision is how little it pushed the law beyond where it already was.
Yeah.
You could, a police officer does not need a warrant to stop someone. It just has to have a reasonable suspicion that the person is engaged in criminal wrongdoing. And at that point could ask for identification, which the Supreme Court has said is not, in fact, a search, and the police officer can demand identification, could then run a warrant search, and if there was an outstanding warrant, even if it's just for a missed court appearance on a traffic ticket, arrest the person, put them in handcuffs, take them to jail. In the process of arresting the person, search the person to make sure that the person doesn't have any weapons or drugs or any other evidence of a crime. And all of that would be admissible.
But,
So
if it was a lie, what the cop said was a lie whenever he made the stop, that's because that's flagrant, and even the justice who wrote the opinion said that separates it out from the innocent mistakes of a stop that may have turned out to be wrong.
So what this decision did the step that it took beyond that was to say, even if the initial stop, even if there was no reasonable suspicion for the initial stop, and here the police officer had stopped someone who was walking out of a house that he suspected there was drug activity in the house, but didn't have any real evidence that there was drug activity in the house. It was just sort of a hunch. Even if that initial stop was unconstitutional, then the fact that there was an outstanding warrant kind of cleanses the taint of that unconstitutional conduct, and any evidence that's found later is admissible. That does bother me.
You think it's overreaching?
I think it's overreaching because, and I think that Justice Sotomayor's dissent in this was actually very persuasive. There are lots and lots of people with outstanding warrants.
Oh, tens of thousands.
And if the police can now just walk up to anyone on the street and stop them, demand their identification for no reason whatsoever, and then run a warrant search, and if there's a warrant,
So there
search them.
are more Fergusons in our future.
And one thing that's
except
interesting is,
Ferguson
the
was
court
alive,
said, well,
so-
you have a remedy, right? If the cops do this, you can sue them. But good luck actually recovering damages when the cops do this illegally to you.
Yeah,
That's a good point.
Right,
okay.
right.
Let's talk a little bit about, I know politics kind of moves into the court. We have a presidential election this year. We have one vacancy and potentially more. Thomas now is making rumblings he wants to leave. You have a couple, 2 or 3 judges in their 80s. So there's going to be probably 2 or 3 judges appointed on the Supreme Court by the next president. So if that's Hillary Clinton, all these things that David mentioned are fair game. I mean, in terms of broadening the right to abortion to basically be anytime, any place, anywhere. I think that's one example, because I think the court's going to go left with her. With Trump, I mean, who knows? I mean, it's like, I have no clue, and neither do you. But I wanted your take as to where that is all going to fit together as we go forward in Supreme Court jurisprudence.
I'm shocked if they could come up with an answer to that
Oh,
question.
these guys are good. They have answers
well,
for everything.
before we even get to who Hillary Clinton or Donald Trump will nominate, we have to ask what the Senate is going to do with the pending nomination of Judge Merrick Garland.
That's a good question.
And even if nothing happens with that, and the next president is the one that makes the nomination, the thing that's been holding up Judge Garland is the Senate. And the Senate has to go along with the president's nominee and confirm the president's nominee.
So, Rocky,
the Senate's going to have a big say in who that
So
next
after the
person is.
election, let's say it's Clinton wins. Does the Republican Senate then decide?
Judge
Judge
Merrick Garland is a little bit left of center, but not by much, and he's
So
actually.
you say he gets confirmed.
I would not be surprised if Clinton wins if the Senate doesn't decide
Yeah,
that.
and you know what?
In fact,
Yeah,
I
They
predicted
either
Judge.
they either take that guy, or it's Miss Warren is on the Supreme
oh my
Court.
God.
No, that was not going to happen. But Judge Merrick Garland, for instance, I mean, I actually thought in 2010 that he was going to get the nomination. He's a pretty well-respected centrist judge, respected on both sides of the judiciary. You know, both from people who are more associated with Republican politics and Democratic
He
politics.
may be a friend of Donald Trump. Who knows? Trump may renominate him if he becomes president.
We can't leave out race because that came into a decision in Kentucky, where a Kentucky prosecutor struck all black folks, and especially 2 with peremptory challenges, which means for no good reason, as long as the judge doesn't find any good reason, you can get rid of black jurors. Robert says, it was 2 peremptories. He says 2 peremptories on race are 2 more than the Constitution allows. My question to you is, what's the punishment for a prosecutor who commits these egregious acts? And where is the court that is going to create, a punishment so that it becomes the Batson case, which does not allow these peremptories of blacks to occur? What's your remedy?
Well, I mean, the remedy is that the criminal a lot of times gets to walk free, right? Which should incentivize them. But a lot of these cases they're deciding today actually happened a long time ago, and so one thing you got to kind of keep in mind is that prosecutors have absolute immunity, and there's some good reasons for that. So you really can't come after them and sue them. So it's a matter of ethics and a matter of potential disbarment, things like that. And some of these standards when some of these cases were originally decided, in fact, I think on this case it was from 30 years ago, if I remember correctly, something like that, that some of these standards weren't as well set out by the Supreme Court at that time.
So we have Louisiana, which says that the mandatory life without parole for juveniles who've committed murder decision previously made is now retroactive. 2,000 cases up for grabs. You approve of that decision? You got 30 seconds.
You told me we weren't going to talk about complicated procedure, and there is very little
I just asked
that
whether
is
you
more
liked it.
complicated than habeas corpus procedure.
15 seconds.
Yeah. You can do it. You can do it.
You can do it at 15, no, 10.
You can say.
So the answer
You
is
can-
when
you can say
we
whether you like
have
it or
people
not.
who've
Time's
been
up.
in jail for a
The
long
answer is
time.
time's
Yeah.
up, so you're off the hook. Rocky Roads, Teddy Ray, thank you so much. It was
Sorry.
fascinating. Thanks for viewing us this week. We had a good time. We want you to like us on Facebook and also go to our website and you can watch and review this show again. You can probably memorize it if you want. We will be seeing you soon with new shows. Thank you, Dave.